In 2022, a federal district court in Texas vacated a major federal firearms regulation nationwide, effectively erasing it across the entire country with a single ruling. That regulation had been issued not by Congress, but by the Bureau of Alcohol, Tobacco, Firearms and Explosives. Within months, federal appellate courts were split, emergency appeals were filed, and the Supreme Court was asked to intervene. Here's the surprising legal reality. Some of the most consequential federal firearms policies in recent years have not come from new legislation passed by Congress. They have come from regulatory reinterpretations issued by the ATF, and those reinterpretations are now being aggressively challenged in federal court. So here's the question I want you to think about as we begin. When a federal agency changes the meaning of an existing statute without Congress passing a new law, who ultimately decides whether that change is constitutional? Let me know your answer in the comments, because by the end of this video, you'll understand exactly how that process works and why it matters to millions of Americans. To understand the legal battle over ATF regulations, we need to begin with structure. The ATF is a federal agency within the Department of Justice. It enforces federal firearms laws, including the National Firearms Act of 1934 and the Gun Control Act of 1968. Those statutes were passed by Congress. They define key terms like firearm, machine gun, rifle, and dealer. But here's where the tension arises. Statutes are written in general language. Agencies implement them through regulations. And when agencies interpret ambiguous statutory terms, they sometimes expand, or critics say redefine, the scope of the law. That dynamic has been at the center of multiple high-profile legal challenges in recent years. One of the most significant involved bump stocks. After the 2017 Las Vegas shooting, the ATF revisited its prior classification of bump stocks. For years, the agency had determined that bump stocks did not qualify as machine guns under federal law. But in 2018, the ATF issued a new rule declaring that bump stocks fall within the statutory definition of machine gun under the National Firearms Act and the Gun Control Act. This reclassification effectively banned civilian possession of bump stocks nationwide. The legal question that followed was profound. Did the statute, as written by Congress, actually include bump stocks within its definition of machine gun? Or had the ATF rewritten the law through regulatory interpretation? Federal courts were divided. In 2024, the Supreme Court resolved the issue in Garland v. Cargill. The court held that bump stocks do not qualify as machine guns under the statutory definition enacted by Congress. The majority opinion focused heavily on statutory interpretation, specifically the mechanical meaning of the phrase, single function of the trigger. The court reasoned that under the statute's text, a machine gun fires multiple rounds with a single function of the trigger. A bump stock-equipped rifle still requires the trigger to reset and function repeatedly. Therefore, it did not meet the statutory definition. The ruling was not framed as a Second Amendment decision. It was a statutory case. The court did not declare bump stocks constitutionally protected. Instead, it concluded that Congress had not banned them in the statute as written. That distinction matters enormously. The Supreme Court did not say the government lacks authority to regulate bump stocks. It said that if such regulation is to occur, Congress, not an agency, must clearly authorize it. This reflects a broader constitutional principle rooted in Article 1. Legislative power belongs to Congress. Agencies enforce and implement. They do not create new criminal prohibitions absent statutory authority. Now, this leads to another major doctrine at play: the separation of powers. When agencies interpret statutes, courts historically applied a doctrine known as Chevron deference, derived from Chevron USA, Inc. vs. Natural Resources Defense Council in 1984. Under Chevron, courts often deferred to reasonable agency interpretations of ambiguous statutes. But in recent years, the Supreme Court has signaled growing skepticism toward expansive agency interpretations, particularly when they carry major economic or political consequences. That skepticism has been expressed through what is known as the Major Questions Doctrine. Under this doctrine, courts require clear congressional authorization when agencies assert broad regulatory authority over significant policy issues. In cases like West Virginia versus EPA, the court made clear that agencies cannot rely on vague statutory language to justify sweeping regulatory power. That principle has directly influenced how courts evaluate ATF rules. Another major ATF regulation currently challenged in federal court involves stabilizing braces, devices designed to attach to certain firearms. The ATF issued a rule reclassifying many braced firearms as short-barreled rifles under the National Firearms Act, subjecting them to registration requirements and potential criminal penalties. Again, the legal fight is not merely about firearms policy. It centers on statutory interpretation and administrative law. Does the statute's definition of rifle clearly encompass braced pistols? Or did the ATF stretch the statutory language beyond its original meaning? Several district courts issued injunctions against enforcement of the rule. Appellate litigation followed. The arguments on both sides illustrate the complexity of modern administrative law. Supporters of the ATF's rule argue that Congress gave the agency authority to interpret technical firearm classifications. They contend that regulatory updates are necessary to address evolving firearm technology. They emphasize public safety and argue that the statutory framework was intended to adapt to new configurations. Opponents argue that the rule effectively criminalizes possession of firearms that were previously lawful under long-standing ATF guidance. They claim the agency reversed course without new legislation and imposed felony-level consequences through regulatory reinterpretation. The courts reviewing these cases analyze multiple legal dimensions: statutory text, historical meaning, administrative procedure, and constitutional limits. And we cannot ignore the Second Amendment dimension. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. That decision significantly reshaped Second Amendment jurisprudence. The court held that modern firearm regulations must be consistent with the nation's historical tradition of firearm regulation. Bruin rejected the two-step scrutiny framework many lower courts had applied. Instead of balancing governmental interests against individual rights, courts must now examine historical analogs from the founding era. This historical tradition test has added another layer to challenges against ATF regulations. Litigants now argue not only that certain regulations exceed statutory authority, but also that they violate the Second Amendment under Bruin's historical standard. However, it is important to clarify what Bruin does and does not do. It does not invalidate all modern firearm regulations. It does not eliminate licensing requirements. It does not prohibit background checks. It does not render the ATF unconstitutional. Instead, it changes the analytical framework courts use to evaluate whether specific regulations are consistent with the constitutional right to keep and bear arms. Understanding that nuance is critical. Now let's consider how these legal battles unfold procedurally. When the ATF issues a rule, it typically does so through notice and comment rulemaking under the Administrative Procedure Act. That statute requires agencies to publish proposed rules, allow public comment, and respond to significant concerns before finalizing regulations. Challengers often argue that the ATF violated the Administrative Procedure Act by acting arbitrarily or capriciously, failing to adequately consider reliance interests, or exceeding statutory authority. Courts reviewing these claims examine the administrative record. They do not substitute their own policy judgment. Instead, they determine whether the agency acted within its lawful authority and followed required procedures. And here is something many people misunderstand. A court striking down an ATF rule does not automatically erase the underlying statute. It means the specific regulation implementing that statute was found unlawful. Likewise, when a court upholds an ATF regulation, it does not necessarily mean the Supreme Court has spoken on the matter. It may simply reflect that the lower court found the rule within statutory and constitutional bounds. These cases often take years to resolve. They move from district courts to appellate courts, and sometimes to the Supreme Court. During that time, injunctions may pause enforcement in certain jurisdictions. This creates temporary legal uncertainty. If you're following these developments, you may wonder, why do different courts reach different conclusions? The answer lies partly in judicial philosophy. Some judges apply textualism strictly, focusing narrowly on statutory language. Others are more inclined to defer to agency expertise when statutory ambiguity exists. Additionally, after Bruin, courts must engage in detailed historical analysis, often reviewing centuries-old firearm laws to determine whether modern regulations have historical analogs. That process is complex and sometimes yields differing conclusions. Let me pause here and ask you something. Do you believe federal agencies should have flexibility to adapt statutes to modern technology? Or should Congress be required to amend the law explicitly every time technology evolves? Share your view in the comments. There are serious constitutional arguments on both sides. Now, beyond the legal doctrine, what does this mean for ordinary Americans? First, it means regulatory stability is not guaranteed. A firearm accessory considered lawful under one administration may be reinterpreted under another. That reinterpretation may then be challenged in court, creating uncertainty. Second, it underscores the importance of legislative clarity. When statutes are vague, agencies interpret. When agencies interpret broadly, litigation follows. Third, it demonstrates how administrative law shapes daily life in ways many citizens do not notice. This dynamic is not limited to firearms. It affects environmental policy, healthcare regulation, financial oversight, and more. The ATF litigation simply provides a vivid case study because the Second Amendment is explicitly enumerated in the Constitution. Now let's address a common misconception. Some believe that when a court strikes down an ATF regulation, it automatically means all similar regulations nationwide are invalid forever. That is not how the system works. Court rulings are limited by jurisdiction unless issued by the Supreme Court. District court rulings may apply nationwide if structured that way, but appellate review can narrow or reverse them. Moreover, Congress retains authority to amend statutes. If Congress clearly defines a term, agency interpretation disputes diminish. The constitutional system is iterative. Agencies regulate, courts review, Congress legislates. The branches interact continuously. Another critical legal concept in these cases is criminal liability. Many ATF regulations carry severe penalties. Violations of the National Firearms Act can result in felony charges. When criminal liability is at stake, courts sometimes apply the rule of lenity, a principle stating that ambiguous criminal statutes should be interpreted in favor of the defendant. This principle influenced the Supreme Court's reasoning in the bump stock case. When ambiguity intersects with criminal penalties, courts hesitate to expand definitions beyond clear statutory text. This is not a policy judgment. It is a long-standing rule of statutory construction designed to protect due process. And that brings us to due process concerns. When an agency reverses a prior interpretation and criminalizes previously lawful conduct, litigants argue that such shifts raise fairness concerns. Courts assess whether regulated parties had fair notice of what the law required. These are not abstract debates. They affect individuals who must decide whether to register, modify, surrender, or retain property based on shifting regulatory interpretations. Let's step back again. The Constitution establishes 3 branches of government. Congress writes laws. The executive enforces them. The judiciary interprets them. When disputes arise over the meaning of a statute, especially one carrying criminal consequences, the judiciary acts as referee. That structural safeguard is precisely what we are witnessing in the ongoing challenges to ATF regulations. Now, another question for you. Should courts prioritize historical tradition under the Second Amendment, even if modern technology differs significantly from 18th century firearms? Or should contemporary public safety concerns weigh more heavily? Consider the implications carefully before answering. As we move forward, watch for 3 major factors in these cases. First, how clearly did Congress speak in the statute? Courts increasingly demand precision when agencies claim broad authority. Second, how does the regulation align with historical firearm regulation traditions under Bruin? Third, did the agency follow the Administrative Procedure Act properly? These 3 pillars, statutory authority, constitutional compliance, and procedural regularity, form the backbone of modern ATF litigation. Before we close, I want to emphasize something important. This discussion is informational. Firearms law is complex and fact-specific. If you are personally affected by federal or state firearms regulations, consult a qualified attorney in your jurisdiction. Court rulings evolve, and compliance requires up-to-date legal guidance. Understanding these cases is not about taking sides. It is about understanding how constitutional governance functions. Here are the 3 most important takeaways. First, federal agencies like the ATF do not operate with unlimited authority. Their power flows from statutes enacted by Congress. When they interpret those statutes, courts review whether the interpretation stays within lawful bounds. Second, the Supreme Court's recent jurisprudence, particularly its emphasis on textualism, the major questions doctrine, and the historical tradition test under the Second Amendment, has reshaped how firearm regulations are evaluated in federal court. Third, these legal battles illustrate the living structure of American constitutional government. The branches check each other. Agencies act. Courts respond. Congress retains ultimate legislative authority. For ordinary Americans, that means rights, regulations, and responsibilities are shaped not only by elections, but by litigation, by careful judicial analysis of words written decades or even centuries ago. Law is not static. It evolves through cases, controversies, and constitutional interpretation. And when you see headlines about ATF regulations being challenged in federal court, understand that beneath those headlines lies a deeper constitutional dialogue about power, rights, and the meaning of statutory language. That dialogue is ongoing, and its outcome affects far more than a single regulation. It defines the boundaries of federal authority itself. Understanding that process is not optional in a constitutional republic. It is essential.